Brandon helped me figure out what to do here. It was we
Oh.
tried all the obvious things, and then we thought of something totally not.
Yeah, all the things people told us it was wrong.
Yeah.
Yay, Brandon.
It was the light there.
So for those of you who are watching on YouTube, we have been off the air for a while because somehow we got disconnected from our Zoom page, but thanks to the help of my intern, Brandon Toby. Okay. So anyways, I'm not sure if that was clear, but we got it fixed and we're back on. So welcome back for those of you who've been watching this. And we're about to start a hearing in about 10 minutes or maybe a little bit sooner on the, we have a couple of cases set this morning, but welcome back. I'm excited we got this finally fixed. It was a far simpler solution, I think, than we thought it would be. Yeah, exactly what the Google was explaining it was. I'm now sharing screen to my Odyssey, which I'm able to do now. And that actually makes things go a little bit more smoothly. We've already had a couple hearings this morning. Brandon, are you on? Mr. Tillotson, are you there?
Yes, I am, Your Honor. Good morning.
Good morning. Mr. Godwin, are you there? All right. I want to let you know we've been off of YouTube for over a month, and this is my first hearing. We finally got our connection reestablished, so you guys are going to be YouTube stars again, and we've already started recording, and YouTube has started. So,
Excellent.
Tony, let's go ahead and go on the record on this case. It's the Thompson case.
Yes, Judge.
Okay, we'll go on the record on cause number DC 1900644, Thompson Petroleum Corporation versus Peterman. Counsel, make your appearances.
Good morning, Your Honor. Jeff Tillotson and John Patton here on behalf of the plaintiffs.
Good morning, Your Honor. Don Godwin, Todd Shadle, and Charmaine Becken Borges on behalf of the defendant, Paul Rudnicki.
All right, why don't we go ahead and proceed?
So, Your Honor, you indicated this will be a status conference regarding the trial date that's upcoming on October 12th. I worked with my clients and Mr. Patton over the weekend. I sent a proposed trial plan to Mr. Godwin to allow us to do the trial. It involved stipulating to 6 jurors, allowing any witness, including a party who wanted to testify remotely, to do so, to limit the courtroom to 2 lawyers and 1 client, no more than 2 lawyers and 1 client at the time, that parties could attend remotely, as could lawyers. It involved asking Your Honor to tell the jury that we had been limited to that number of people, so the plaintiff wouldn't be at a disadvantage that not all their clients could be in the courtroom. That to essentially to work it through scheduling such that the trial would start October 12th with jury selection at Frank Crowley and finish by Friday of the following week, which, when we went back and looked at witnesses, would be slightly no more than a 2-week trial, but really realistically a few less days, because we'd start on a Tuesday, do jury selection on Tuesday, start the trial on Wednesday. And we thought separate exhibit binders for jurors, so we're not handing stuff around to everyone. We would follow the court's protocol regarding masks or whether the jurors could leave or whatever. And so we thought that would work. We could pull that off for October 12th. Obviously, my clients are between saying, we never want to leave our homes because they're old and have conditions, and this is wearing on them as to when and are they going to have a trial and how are they going to do it. As I told the court, Miss Dorothy Thompson is 90 years old, and one of our other clients has health issues, and so it's a concern for us. We need to get this done and over with. So I propose that I'll let Mr. Godwin speak for himself, but I will steal the headlines. He rejected all those conditions somewhat disappointingly, and believes the trial should be rescheduled for sometime in 2022 when there won't be as many COVID protocols, presumably, on it. And I just tell the court, although I don't want anyone's health in any way to be compromised or put at risk, I'm on the board of Parkland Hospital, as Your Honor knows. We're committed to ensuring the stopping of the virus, and we've spent time and effort encouraging people to be safe. That said, there has to be some legitimate compromise between having a trial on October 12th, where people might feel they're at risk, and being reset to sometime in the first quarter or second quarter of 2022. And I will say this, if the expectation is that one day within the next 6 months, we're not going to have to deal with COVID as part of our trial, I don't see that happening. It may be better, it may be worse, but I don't see it disappearing from the landscape, and therefore we just have to deal with it in some way or another. So I'll throw out just two options on the fly that Mr. Pat and I thought about. One is, to somehow try and make it work. Two is to reschedule us, but keep it tight. Push us back 30 days. See where the numbers are. On our original trial date of October 12th. Hear our Daubert motion in an effort to maybe streamline some portions of the case between now and then, but push us back no more than 30 days. That would allow us to perhaps have better numbers and a better realistic idea of what we're doing. Perhaps I could convince Mr. Godwin that 6 isn't as bad as everyone seems to think it is. By the way, just one point. People seem really hung up on that, but as Your Honor knows, many times defendants remove cases to federal court and you get 6 or 8 jurors in federal court. They don't do a panel of 12 in a civil case. So it can't be that bad. I'll just throw that out on it. So anyway, so I would ask that for it, Your Honor. We could still keep the remote testifying in place in November. Mr. Rudnicki the defendant is a much younger person, but there's no reason anyone on his side should be put at risk in any way. That's not my intent. And I don't want to get into weighing who's more at risk than not. Everyone should be concerned about protecting against the virus and their kids and their spouses and everyone. So that's kind of our view on it. I realize it's not a very disciplined proposal I have to you. I don't think the court can make Mr. Godwin or any defendant stipulate down to 6. And even if you did, there'll be some logistical problems in October. There will be for a trial this size. But if we're going to get reset, we can always get reset later and later. But hold us to November. 30 days, November 12th. So I don't know where we would be on Your Honor's docket, but surely we're going to be one of the older cases. Go from there.
Well, let me raise one issue that I think is important to think about, because I kind of mentioned this at the last hearing, and I did some research and have more information about this, is that I really think, given our current COVID protocols, it's virtually impossible if we're going to do a 12-person jury, especially on a case like this, to do it in my courtroom. And so, and again, none of us know how long we're going to be doing these protocols. Everybody is, ever optimistic. Judge Hoffman used to think that this thing is going to be over. We're going to be in, it's going to be in our rearview mirror, and I just don't know when that's going to be. But we've got to start figuring out a way to try cases. The Merrill Hartman, I'm going to actually, I think I told you I have another case that's starting this Friday. That's not quite as long as this one. In that case, we were able to get the Merrill Hartman for the whole week. And so we might have a better shot if we really have to do a 12-person jury. doing it now before the Court of Appeals goes back into kind of doing in-person hearings. They use the Merrill Hartman quite a bit in normal times. And so if we're going to stick with the 12-person jury, it might make more sense. I guess my view is if we really have to do a 12-person jury and we have no idea when this is going to be over, at least let's do it while we have is there someone named Forge who's joining us? You guys know
Not from
who
our
that
side.
is?
Not from our side.
Judge.
Forge? I don't know what that is. Okay. I'll let him in. I'll see what it is. It might make more sense to just stick with the October 12th date. If we can agree to a 6-person jury, I could do this in my courtroom and I have a lot more flexibility, if that makes sense. And so anyway, so that would be the only other thing that I would say is I don't know that if we can agree to a 6-person jury, I don't mind moving it to sometime early in 2023 to give us more time to let COVID. But if I'm going to have to do a 12-person jury, then we might as well just do it now is my at least my initial thought. Mr. Godwin?
You talking starting in the morning, Your Honor?
I'm sorry?
You start talking about starting in the morning? You say.
I can't hear you. I'm sorry.
Majority, we have to turn down. You're on. We're up, Judge. Can you hear me now?
Yeah, were you able to hear me okay?
I could hear you okay, and I was talking. And could you hear me, Jeff?
I could.
Okay, Judge, can you hear me now?
Yeah, so there's someone here named Forge. Is that who is that? Are you here for something?
I see him on the screen, Your Honor, but I have no idea who those folks are.
Are you guys here for a hearing?
Yes,
What are you here for, ma'am?
Genevieve Richards.
Let's see. Genevieve Richards. Familiar with that. Let me see.
You want the cause number?
Yeah, that would be great. What is it?
TX 50185.
That is not a
No,
cause.
I'm sorry, sir. It's TX 11-50-185.
That's still not I don't think a cause number.
Well, I'm reading it off my paper.
Let me just see real quick. Genevieve.
And it's Genevieve Richard Elta, ETAL.
Okay, let's see. Let me try this DC 11. I don't think that's a cause number. 50.
It says cause number TX 11-50185.
Is this for the 68 District Court?
Yeah,
It is, because that our cause numbers start with DC, not TX.
but I'm reading what's on my paper, sir.
What paper are you looking at? Let me see. I can't read that. Can you push it up a little bit?
No, here's the number right here. In the left-hand corner.
Okay, move it up a little bit. Let's see.
Are you showing him down there? He said move it up.
Yeah, that's not. That's Felicia Petrie. Let me see. Move it up a little bit. I have no idea what that is.
Okay, let me tell you something, sir. This is the first paper we got. I don't have the second paper the second letter you sent me. This the first letter y'all sent me.
We didn't send you that letter though. That's from the clerk's office. Not from my office.
Okay, well, it was 6 of us, so I'm fixing to call my sister and
Okay.
see what she have.
It should be a cause number that starts with DC if it's in my court. The TX cause number doesn't make any sense to me. That's not a cause. Maybe is it possible that could be in criminal court?
Now,
Because some people get confused sometimes. There's a Judge Peggy Hoffman and I'm Judge Martin Hoffman. Is it possible that you're?
see, this is what we had to go to first, and so I just assume we go back to the same court.
I don't know. It's not a cost number out of my court.
Okay, so what you got?
Why don't I do this? Why don't I put you on mute?
Your Honor, may I interrupt? We searched it online just to help.
Yeah,
Was it is showing in the 68th, is it not?
for the TX cost number.
You through?
Yes, TX 11 50185.
Let me find. I've never.
Yes.
Showing Carl Ginsburg as the judicial officer.
Oh, it's a tax case. Okay,
Tax case.
that's what it is.
Mm-hmm.
Okay.
What time did it start?
You're going to need to reach out to Judge Ginsburg. He's the tax judge for all the courts. Can you hear me, ma'am?
You say what, sir?
You need to reach out to Judge Ginsburg. He's the tax court judge,
Okay.
and he handles all of our tax court cases. So you'll need to reach out to Judge Ginsburg's office.
And how do I do that?
I would just look online for it. It's Judge Carl Ginsburg. He's our tax court judge.
How you spell his name?
Ginsburg, Ginsberg.
Wait just a minute, sir. You caught me off guard there. G-I-N what?
G is in girl, I-N-S, B is in boy, E-R-G.
Did you give me a number? Oh, you have to look it up.
Let me see. If I
Oh,
can-
can you give me the car's number? We in the wrong court. Oh, we in the wrong court. The man said he just looked it up. Oh, so I probably need to hear know the number, the car's number. So can I call this same phone number and they'll tell me the court number?
Let me see. So his phone number is 214-653-6061.
Okay then, thank you. Thank you, sir.
Ma'am,
Good luck.
Ma'am,
Yeah.
you're set for a noon hearing, and in that letter, it gives you a link for how to determine how to sign in for that hearing. It's a different link than this one.
It's
So
not
if you
a
look at the letter,
12.
it'll be on there. It'll be on there.
Okay, thank you so much.
Good luck. All right, thank you.
Good luck.
And I told you to. It is.
What, how they got your link, Judge, to your court?
They probably called my coordinator and I would guess, and she just gave it to them,
Judge.
thinking it was a hearing in my court, but.
They're getting their trial. Come on.
Right.
All right. So I'm sorry, Mr. Godwin, we couldn't hear you so well before. So
Okay.
what were you saying?
Yeah, let me say, Judge, that obviously, we agree, Mr. Rudnicki and I, everybody on our team, this side, as I know it as well as on Mr. Tillotson's side, we all believe and that the health of everybody is tantamount to everything we're doing here. Both parties on both sides have a lot of money. It's not like anybody needs this trial to resolve something, to pay a mortgage with or pay off a note or whatever. There's ample funds on both sides. But that's really not the point. The point is that my client is being sued for over $100 million. That is the majority of his personal estate. It would wipe my client out if he loses that amount of money. So therefore, he has asked me and insisted, with all due respect, to me and to the court, obviously, that he be afforded every right that he's got available to him. And he lives in California. I don't see him very often. I don't talk to him very often, but when I do, it's always very pleasant, and one of wanting to make certain that everybody stays safe and that we move the case along. He obviously wants to move it along as well, and no question about that. But at the same time, he wants to be afforded whatever his rights are. Judge has told me that he will not agree to less than a 12-person jury. I have tried many cases in federal court with fewer than 12. I've tried many cases in county courts at law with 6 jurors. So it's not like anything less than 12 bothers me. That doesn't bother me at all. I'm used to trying cases in whatever court I'm in and with the jurors that you have. But in district court, he's entitled to a 12-person jury, and that's what he wants to insist upon. I would also say to Your Honor that until yesterday, when Mr. Tillotson sent me his proposed trial plan, which I appreciated, and I took overnight and tried to contact my client, finally made contact this morning, and we got him back our proposal this morning as Jeff requested. But that was the first time I'd heard that we weren't looking at least a 2-week-long trial. Yesterday, they said they thought it should be limited to 8 trial days, is the way I read the proposal they have. I've always said and been consistent that I believe that including the jury of a day or less than a day, picking the jury, that it's going to take between 2 and 3 weeks to try this case because of the sheer magnitude of the numbers and the number of witnesses and the complexity of it. It's not an easy case. It's a very complex case, and with a lot of tedious information that's going to be coming from the various witnesses. So we think 2 to 3 weeks long is what we're looking at. Jeff had proposed that, Mr. Tillotson proposed that the parties not be required to be in the courtroom. My client is entitled, I believe, to have it face his accusers in open court. And if that's not the case, the court just going to tell us that, and I understand. But he wants all the parties themselves to be in open court, and certainly with.
Let me just say, Mr. Godwin, that is a non-starter. Under at least unless something's changed under the most recent emergency Supreme Court order, I think I have the right to be able to require that, and I'm going to allow that in every situation. I think if we want to have a safe trial, I'm going to do everything I can to do this as safely as possible. That means that any witness can testify remotely that wants to, and any party can appear remotely that wants to.
Well, I understand that, Judge. I do, and I respect that. I know what the rule is. You'd asked me to tell you what our position was, and I'm simply doing that, not to be difficult, but to tell you what my clients, what his ruthers would be. And that was he'd like to be able to have the parties meet him in court. If it's going to be by Zoom, it's going to be by Zoom. But by the same token, I would say to Your Honor, when you're facing this type of a lawsuit with the magnitude of the money that we're facing here, if you delay this trial by a month or 2 months to give this vaccine more time to work, because it is working, and give us a chance to get the boosters, it seems to me that the expediency, while important, should not override the rights of an individual to protect himself as best he can, and then let the jury decide whatever's going to happen. So anyway, having said all of that, Your Honor, we would like a 12-person jury. My client will insist upon that.
So let me just make this as, I guess, as respectfully, but also as clearly as possible, is that by insisting on a 12-person jury, your client is making this as difficult as possible for us to try this case. We have very limited options with that. I think we can get this tried. I need to verify it on October 12th. I'm not sure in the future. And so the two approaches I would suggest is, and run these by your client, is that we go to trial on October 12th. I'll limit presentations to 25 hours per side if we have to do it that way, because I have the right to do that. We'll limit the all witnesses can appear via Zoom, or we agree to a 6-person jury. We move this to next year, early next year, and with no time limits. And if we're no longer in red, we'll do a 12-person jury. If we're still in red, we'll do a 6-person jury, so that we have some ability for me to be able to try this case, because there isn't, unless Mr. Tillotson, do you agree that in a month or two that we're going to get out of red?
Hard to predict, but I would say no. I think by next year you will be, so there would be a good chance you could have your 12-person jury if you wanted it, but you'd have your backup if not. I can't predict by November 10th if we'd be out of red or not, but we could certainly try November 12th. If defendant wants 12, I think the court's made a pretty good call, which is let's go do it now, because it's probably just as easy to do it now as it would be to do it in November. In fact, we may be easier now than November, given the use of the large courtroom. If the defendant agrees with us to stipulate down to 6, then we can do it next year, subject to, if we're no longer at red, then the court can reconsider whether or not to grant the 12th person. To me, that's a pretty simple compromise. I do think limiting to 25 hours per side will force the parties to be efficient and will not prevent anyone from putting on whatever they think they need to put on.
So when do you guys want to get back to me on this?
I know I have the authority to I've proposed to drop down to 6, so I certainly have the authority for it. And the clients trust the court regarding scheduling. So either proposal is acceptable to us.
It is farther out than you wanted, I know that, but
certainty, if I tell the clients it's going to happen on this date, no matter what, because we've got in place a protocol that the court says it will do. Things couldn't be any worse under COVID than they are now. I mean, I should say that. That's me knocking on wood. Right. That's me knocking on a lot of wood, not a wood. But the certainty of being able to tell my clients it will happen on this date for purposes of their lives and planning and whatnot is better than perpetually resetting it, in my opinion. So I would make that trade. It is further out. I'd ask the court to look at as early 2022 as possible, given the court scheduling. But I would take the certainty of this arrangement. Either you're going to have your trial on October 12th, or you're going to have it, in January, February, whatever of next year. Would be worth that delay. Am I right on that, Judge?
I'm sorry, Jeff, did you finish?
Yeah, I did, Don. I'm sorry, I did.
No problem. I apologize for stepping over you.
No
Your
problem.
Honor, I would also suggest to you this, that we still have pending before the Texas Supreme Court a mandamus on the court's denial of our responsible third party of David Drum and the Carrington Coleman law firm, whose partners are Monica Loughton and others over there in that firm. And the court denied that. The Court of Appeals affirmed it. It's before the Texas Supreme Court. And interestingly enough, Your Honor, recently there was another case out of the Dallas Court, the Fifth Court of Appeals, where a mandamus was granted. And so that's gone to the Texas Supreme Court, and they've asked for a brief to be written on that.
Wait, on our case or on the other case?
On the other case, everything is written on ours. We're waiting for an opinion or decision. It's been written for several days now, but on the other case, Judge, October 4, they're expected to submit their papers on that. And we would expect after that, that because of one mandamus being denied and the other one it being granted, that the court
has the Supreme Court stayed us. If the Supreme Court has stayed us, then we can't go to trial. But if they haven't stayed us, then I'm not delaying this.
Well, I just ask you to consider it.
Yeah.
Is how I'll ask you was to consider it. and so I understand, but I'll go back to my client again. But I can tell you that I believe he's going to want to remain with a 12-person jury, Your Honor. And I understood you to say that's making it difficult. It's not my client's intent to make anything difficult, Judge. He's not trying to do that, and I'm certainly not trying to do it. But there's enough money involved here and the future of his family that he cannot afford to give up on his rights whatsoever. I ask you to consider that.
You got to
But do
make.
you want to get,
May I just throw out one thing because it's important for us to get to trial here. And I want to just make one point to Mr. Godwin that may help. It doesn't really seem to make a lot of sense to say, let's put this trial off till next year because things will be better. When the court is offering that if things are in fact better next year, you have the opportunity to have your 12-person jury. It's only if things stay the same as they are now, we're still in red, that you're going to have a 6-person jury on it. And what that means, if things are as bad next year as they are right now, it means we wouldn't be able to have a trial anytime soon. And so I would ask you just to look at it from that perspective. It's important for us with Ms. Thompson being 90 to get this over with. And so I just would ask you to look at it from that perspective. It seems to me you're getting what you want. You're just gambling that things will be better next year for it. And we're really the ones that are getting put off again on this trial date. So I'd ask you to approach it from that perspective. I just wanted to point that out that, it seems to me that why would we put this off in the hopes things get better? But then think it's a problem, not have a 6-person jury for next year if things aren't better. So that's my only point, Don, if that helps.
so I'd like to have a meeting with both sides clients here on the Zoom so we can kind of talk to them about logistics. How many, do we have one attorney? We have one party per side, or is it two? You have 2 clients, Mr. Tillotson? Is that right?
Three
Clients.
Mrs. Dorothy Thompson, and then her 2 daughters, Linda and Christy Thompson.
So when would be a feasible time to kind of chat with them and give them the different options? And I do want to verify that we can get the Merrill Hartman for 2 weeks. I'm not 100% sure of that, but
yes, Your Honor. Well, they'll be flexible since it's Zoom. We can make them flexible.
We will as well, Judge. Today is going to be rough because of other commitments that I have through today. But after today, tomorrow, rest of the week, I'll do everything I can to make my client available. There is a 2-hour difference, but we'll try to work around that, Judge, and fit your schedule.
do you want to shoot for maybe 10:30 tomorrow?
Let me look here, Judge. Sound okay?
Yeah, that's right.
Yeah, 10th.
Yeah, we can make anything work, but that's when his kids are going to school.
10:30 tomorrow. That'll be 8:30 out there. 10:30 tomorrow, Your Honor. Well, if you don't hear back from us, I'd contact your office and Jeff if that doesn't work. Otherwise, we plan to be available for a 10:30 call in the morning, and we assume your office will provide the Zoom information.
Yeah, Rhonda, go ahead and send them. Oh, I don't know if Rhonda's on here. We'll need to go ahead and send them a Zoom link. So we'll send you a Zoom link.
Yeah,
does everyone understand kind of the 2 options? And in the interim, I'm going to try to find out for sure that we can get the Merrill Hartman for those 2 weeks. I won't reserve it yet, but I just want to see if that's available. And if there is days that it's not, then how we work around that. But I really urge you, Mr. Godwin, that this is not normal times. I've tried hundreds of 12-person juries. It's not that I don't want a 12-person jury. I just don't know how to do this. And at some point, we've got to get this resolved. And so, you talked about wanting to be safe. This is the only safe way I can think of doing this, is either do it in the Merrill Hartman when we can get it, or with a 12-person jury, which could be very difficult next year, or doing it as a 6-person jury. And all but one of my trials I've done since COVID has been 6-person. So don't feel like you're the only one that I'm suggesting this to. It's just, if the people who designed this courthouse knew that COVID was coming, they would have given us bigger courthouses, I'm sure. But our courtroom is just not big. Our bigger courtrooms are just not big enough to do 12-person jury safely. And so we just don't have a lot of options with that, in my opinion. And so talk to your client about that, and also tell them, look, if things do get better, if you're kind of taking a chance there, if things do get better, then you'll get your 12-person jury. If we're out of red, it's an objective thing. It's not when I think it's better. The county says we're out of red, then I'm happy to do a 12-person jury because we won't be limited by the fire marshal's recommendation. So that would be the things I would strongly urge you to consider, Mr. Godwin, and your client. So,
Well, I talked to him, and I want to say back to the court, when I said the other day that I mentioned we all wanted to be safe, and I do. I don't want anybody, including you, to worry about my safety, Judge. I subject myself to being unsafe every day here in this law firm and coming in here being around people, and I'm willing to do it to represent my clients. So I don't want my safety to be of a concern to anybody, including the court. I'll take care of myself.
everyone's safety is a concern to me, including
It
yours,
is to me
Mr.
as well,
Godwin.
Judge. It is to me as well. But I don't want you thinking that I'm asking for any special favor because of my safety. I'm not asking for that,
Okay, I wasn't thinking that at all. So
Judge.
but I want to make sure everybody's safe that's here. And so the protocols that Mr. Tillotson suggested about doing everything remotely, as much remotely as we can, trying to do limit the number of people in here. I think those are all excellent suggestions, and it would allow us to try this case. So let's try to figure out a way to do this safely. If we have to do the Merrill Hartman and do 12-person juries, I think that we might as well do them now as opposed to next year when we may not be able to. So, but all right, guys, we will see you tomorrow at 10:30.
See you at 10:30, Judge.
Thank you.